Welcome to Who Wrote That Up for You, a daily podcast that shines a light on the American justice system and its role in empowering the powerful to take from you. The justice system is the only branch of your government where an individual, rather than the collective, can make the system act for you. It puts power in the individual's hands, but it's broken and being used against you at a time when you need it most.
And welcome to Who Wrote That Up for You. I'm Sonia Ebron, a co-founder at Courtroom 5.
And I'm Deborah Sloan, the other co-founder at Courtroom 5.
Delightful show lined up for you today. In a few moments, we will speak with Joryn Jenkins. She is the founder of Open Palm Law, a divorce mediator, a Florida attorney, and an expert in collaborative law. So we'll get a chance to speak with her about all of those topics in just a moment. Before we get there, though, Deborah, what's on your mind today?
Well, on one of our previous podcasts, we talked a little bit about some a recent decision that the California Supreme Court made. And I loved that decision. And now let's talk about the Florida Supreme Court. The Florida Supreme Court recently approved a pilot program to authorize courts to explore the idea of online courts for small claims, either through something like online dispute resolution or some other software to facilitate entirely a largely online resolution for cases. On the surface, it sounds good because they claim that it will make the legal system, the legal process transparent and easy to access, more available, inexpensive. It's going to be quick, and therefore, they say, it's going to make it trustworthy. And I guess I should have a kind of a wait and see attitude, but still, I'm not trusting this. Not given the Florida court's notorious stance with pro se litigants in general. Can you say rocket docket, forced mediation, closed door hearings in chambers? If this program takes place, it's because it would make the lives of attorneys, judges, and clerks easier, not necessarily pro se litigants. Well, I don't know about that. So, we'll just see what happens. But I guess I can take a kind of wait and see attitude for a few minutes.
A few minutes indeed. I know you've got some bias there for sure. So, I wouldn't pick on Florida. I know that this is a challenge around the country. Courts are overwhelmed, largely with the rise in pro se litigants, but also some corporate bad actors, the debt collection industry, I would call out in particular, for just filing way too many lawsuits against people. I think the courts are in a difficult position here. I mean, they don't drive their own budgets, right? They depend on the legislature and ultimately the citizenry to properly fund the courts, and we haven't done that probably in decades. And so the courts are having to do what they can to survive. I wish, though, they would make some other choices, some smarter choices, in my opinion. There are some opportunities for cost cutting or driving revenue in smarter ways than they do now to sort of balance the books. But ultimately, this is a question of our democracy. We have to have open courts, and that means open for everybody, right? Not just the big corporate entities that are partly responsible for this problem. So, yeah, one day at a time. Let's extend some grace and some hope that they will do some better things, and that their hearts are in the right place at least. So, way it goes. At any rate, thanks for bringing that to our attention. At Courtroom 5, we believe the courts belong to the people, in particular to the people who use them, and we the people are coming to claim our courts. So if you are in court without a lawyer, or you need to sue someone and can't find a lawyer to represent you, get yourself over to courtroom5.com. Give us a try, and we hope to provide some relief for you there. At this time, it's my pleasure to welcome onto the show Joryn Jenkins at Open Palm Law. Joryn, thank you for joining us today.
Thank you for inviting me.
Fantastic. If you would, give us just a brief background and help us understand how you came to divorce mediation, to collaborative law. Whatever you'd like to share there would be awesome.
Well, I started in commercial litigation, basically. I did some criminal prosecution when I was very young. That's how I got into court in the first place. And I loved courtroom work. I loved it. I'm apparently very competitive. My husband likes to point that out to me all the time. And so courtrooms just appealed to me. I love winning. The funny thing is, most people don't realize, think about this, lawyers choose their cases. You don't have to take a case you don't want. So if you're careful about the cases you accept, then you win a lot, even though it's 50-50 in theory. It wasn't until I started doing divorce work. I opened my own firm. I was a woman in practice. It was 30 years ago that I opened my own firm. So I've been practicing 43 years. I opened my own firm 30 years ago, and all my friends, all my commercial litigation friends would send me was divorce work. They assumed I'm a woman, so I would do divorce work. So I learned to do divorce work. And eventually it hit me that families just don't belong in court. They don't belong there. It's a terrible thing. What you're destroying is all of the relationships that don't need to be destroyed. I used to have neighbors come to me for legal advice. $500 an hour. I got this subpoena. I'm paying you because I need help. I got this subpoena. I don't know who's asking me to testify. I don't know who I'm going to be living next to when this divorce is over. I don't want to testify against someone that I might have as a neighbor next year. So, I mean, teachers would come to me, principals, people getting dragged into court who have no business being there when families don't belong there in the first place. You don't need to blow up relationships. When I was 7, my parents were divorced, and I never saw my dad again. And that happens. Not so much these days because the legislatures have created laws about moving out of state, about moving too far away from the other parent, but it happened a lot in the past, and it
Wow.
still happens.
It's extraordinary. It's a great motivation for getting into mediation. I absolutely agree with you. Families may go through different stages, but particularly when kids are involved, it's still a unit that's going to have just a different sort of relationship. And
Yeah.
litigation, we've both been through it. It's a horrible, right? Nobody wins in that. So I'm glad to hear.
Exactly. That's what you finally realize when I used to love winning. That was the whole thing. I love to win. You don't win when you go to court. Doesn't matter which side you're representing, it just doesn't matter.
Exactly. So tell us about your mediation practice then. How do you keep people out of court?
Well, it's funny because you mentioned earlier a lot of pro ses going to court, and especially in the family law space. Last I heard, it was 65% in Florida are self-represented. And by the way, I would do consults all day long and tell people, you can do this yourself. If you're not really adversarial, you can handle this yourself. There are forms online. The courts have created forms. You can use those forms. Maybe you just need a lawyer to help you walk through the forms because you're not sure how to fill them out. Sometimes it can be off-putting, even for lawyers. But so I would help people all the time represent themselves, save money. I don't see any reason to pay a lawyer $500 an hour if you can do it yourself. But when it gets to mediation, when there are some issues that have to be worked out and you can't do it yourself at the kitchen table, which is another form of divorce, then sometimes someone who's neutral can help you see the light, if you will. Often as a mediator, what you're doing is you're just bringing someone who both sides can trust. So you talk about respecting each other. Sometimes the people just won't. They just can't. There's too much water over that dam. I had to think, is it under the bridge or over that dam? But what they do have to do is trust the process. So if you choose a mediator, you find someone who's trustworthy, and you both, if that's the one thing you can agree on, you agree on the process, then that's a start in the right direction. And often what I found is that people just weren't sharing information with each other, so they didn't trust each other. And then once they started sharing, because sometimes that neutral third party can put the word out, share the information in a neutral way, and then it becomes, oh, I didn't realize that was what he was trying to say. And so you have more communication going on. When you see that happening, especially in the collaborative process, it's just awesome. You feel like you're winning all the time.
That's extraordinary. I want to talk about the difference in cost in a moment, but first, the issue of respect. I think it's a no-brainer that the more you can maintain respect for the other party on these issues, the easier the mediation goes. But that's got to be really difficult, I imagine, for divorcing couples. Or what's your experience there?
Well, I usually start my mediations, and most lawyers don't do this, but I start it with both the clients in the room, in the same room with each other. I I do try and act as mediator, even though I've got one here and one here. And I do encourage them to talk to each other, but I will interrupt if they're talking to each other and I see someone getting upset. I really believe in watching body language, watching facial expression, because those are very telling signs. I did a collaborative case where the guy, and we'll talk about collaboration, but the guy shared a secret. His lawyer encouraged him to share a secret. And I watched my client, I was sitting with my client, and I watched how she reacted, and it was not good. And I thought, well, I don't understand why it's not good. He's telling her what caused him to hide this all this time. It's a great story, but it's very long and involved. And so I pulled her out in the other room and I said, why are you so upset? I don't understand. He's told you why he did these things. And he had help because all these neutral people were there with you guys. And she said to me, he didn't share this with me for 5 years. We were best friends all through high school. I can't tell you how much that hurts my feelings. And I said to him, my perception is that he didn't tell you because he values your respect so much that he didn't feel like he could share this, and he never found the right time. He never could. And when I saw the light dawn, and she was like, oh my God. We went back in. Eventually, we got them divorced. We all went to court with them because when you do a collaboration, you want to spread the word that this process exists. The judges need to know about it because it's so empowering, and it's actually rehabilitative. And so we all walked out of the courtroom together. Now that's one lawyer, the other lawyer, the facilitative expert, the mental health person sometimes who helps communications, as I did in that instance, and maybe a financial neutral also. So you have all those people. We were all, and they were walking together, Mr. and Mrs., no longer Mr. and Mrs., walking together, and they're chatting. And I hear her say to him, she turns and she faces him and she throws her arms around his shoulders. And she says, I hope you know I will always love you. Oh my God, it just makes me tear up because you see that kind of change and building of connections. Now, could they get back together? No, too much water over that dam. But are their children going to suffer less in the future because now they know better how to communicate? They learned a lot in the process. I had one guy come out of the process and say, I came out of my divorce a better person. His wife, who had complained initially that he never listens to her, came out and she said, and I don't think she connected because it was 3 months earlier. She said, he never listens to me. She said to me, you know, it's funny, in this process, I learned to listen to my husband better. It's easier to hear him when someone else is helping you hear. So she was watching how his words were landing on the rest of us. We're all neutral. Doesn't affect us the same way it affects her. We all know this, right? We've all been there. And she learned to hear him.
That's amazing. That is amazing. I'm hearing elements of collaborative law interwoven there. Can you tell us what that is, how it works? And I assume not all mediators are doing collaborative
Collaboratively
law.
trained. Yeah.
Right, right.
So
What's
it's
the difference?
interesting. I recently wrote a story about being collaborative in a non-collaborative space, but collaboration technically with a big C is a lawyer for each client, and the lawyers sign a written agreement that they will not go to court. Now, what does that mean to the client? Nothing. it just means that the client has to get a new lawyer if he wants to litigate, if he gives up on the process and wants to go to a judge. But what also happens quite often in the collaborative process is we bring in this communication specialist, this mental health person who's better able to translate than most of us lawyers. I've become, I think, pretty good at it, but because I've become more sensitive over time. I used to tell people I'm not a huggy touchy kind of person, and oh my God, yes, I am. Little did I know. But thank God, because I just had a grandchild. So we have this communication specialist who's neutral, and then we also have usually a financial person who's neutral. So I've done pro bono cases where we had two financial neutrals because we were doing volunteer work. So why not? And we needed them because the guy had a pension from the railroad. It wasn't big by any means, but it was a pension that we needed to deal with. And they had small savings that we needed to deal with. They still qualified for pro bono, which means for your listeners for free. So, I've seen this work in many different contexts, but you have this team approach to dispute resolution. And it's not just in divorce. That's what's really amazing. There's a very small group of people who, well, I'm one of them, because I used to do commercial litigation, and I can see how this could work in a partnership dispute. Say the two of you ladies decide that you no longer like each other, but you have all of this IP that you own. You have I don't know what kind of equipment you have, but you have all of this stuff together. What if you decide to get divorced? That's a divorce. So I've done partnership breakups. I've done, not in collaborative. I did an employment discrimination case in collaborative because the gal felt that she had been discriminated against by the company, but she didn't want to lose her job. And that's kind of hard to negotiate, but we did it. And again, there were some communication problems. The company didn't know what was going on, and when it found out, it had a different reaction, and on and on. So you find these contexts where it works perfectly well, not in an emotional relationship situation, marriage.
Absolutely. That's extraordinary. I'm keying in particular on the commitment of the lawyers involved to not go to court. And that's really interesting to me, because I think many of us assume that lawyers prefer to do these things in court, and mediation is sort of a stepchild. Let's get this thing done as a way of settling. In most cases, as civil cases, as you know, settle anyway. So it's sort of the thing you do before
90%,
you go to trial.
90% of all cases settle in mediation. And in Florida, at least, if you're getting divorced, you're going to go to mediation at least once and probably twice, because the judge is going to make you go.
Right. Nobody wants to go in front of it.
The judges haven't figured out yet that they can force collaboration, and I'm not sure if they can. I'm not going to opine on that, but they do force mediation here. So maybe they can.
It sounds like a very powerful way to mediate. That's for sure. What's the difference in cost? I know that traditional mediation is much less expensive, obviously, than hiring a lawyer and going through the litigation process. But what's the add-on for collaborative law? Is it much more expensive?
So I didn't realize that you were going to go in that direction. Silly me, but I don't know how to share my screen on this media anyway. I've got posters, because I'm also a marketing specialist. So I've got posters. I've got this gigantic poster that goes on my wall, and it goes, okay, here are the types of divorces you can do. There's do it yourself. There's and the other side doesn't answer, so then you get your divorce. You get what you ask for. There's kitchen table. There's someone hires a lawyer to help them do the forms. There's someone hires a lawyer to draft up the agreement. And we're getting more expensive as we go down the list. And then I've got the partnership poster that's here what the costs are, generally speaking. Now, there's caveats. It's Florida, so I don't know what your jurisdiction is. Lawyers charge anywhere from $200 to $650. If they're in Miami, it's $900. I mean, crazy, right? So I tell people these are relative numbers, but I can tell you the relative numbers for mediation. My mediations will run, if you're not represented, they'll run you about a $5,000 ticket. If you're represented, So you have to include the cost of the 2 lawyers. It's going to be more like 10 to 15. If it's collaboration, I've run the numbers on 72 cases. I had a friend and I got together and we collected all that information, ran the numbers, 32 grand if you have kids and a piece of real estate, because children magnify the number of issues, and real property also gives you additional issues that you need to deal with. So little bit less if you don't have that. Strangely, if you look at the 32 grand, it's 10 for one lawyer, 10 for the other lawyer, and 6 for each of the neutrals. Keep in mind, and I tell clients this all the time, the costs are going to be less because your lawyer isn't doing all the financial work. You've got this neutral over here who charges half price for his stuff. He's only $250 an hour. I'm $500 an hour. Same thing for the mental health person. She's only $225 and I'm $500. You don't need me helping you do your parenting plan when there's this specialist over here who's neutral. I'm not neutral. I represent my client, even in collaboration. But there's this neutral who can help you, and they are very proficient at what they do. So the costs go down the more you work within the system. People, okay, I'm willing to collaborate, but I don't want to hire the neutrals. That's a mistake. Hire the neutrals because your costs will actually go down. Doesn't make sense, but it does.
It does, actually. It makes a lot of sense there. That's really interesting. And so if you've got some
lawyers have to be willing to give up control.
Yeah. Yeah.
And many lawyers cannot do that. And I myself am a control freak, but I just love this process.
You have to. I understand. Absolutely. And so if you've got kids, you've got property, and you want to sort of transform the relationship without destroying each other, you want to go this collaborative law process. What if you also have then a business, as you alluded to earlier, and you maybe have to separate things out that way? How does that work?
Many times now, Sonia, keep in mind, more times than not, people who are getting divorced want to keep the business with the other person because the business is successful and it's their income. And so I just finished actually I mediated this one. We didn't need there was a lot of respect there. They'd been married for 30 years. Their business was very successful and they were just romantically ready to move on. And so I just mediated that one. But so if you also have the business to divvy up, it actually is less problematic because one of you, it's kind of like having a piece of real estate. One of you is going to have to give it up. And if you aren't willing to do it voluntarily, the judge will decide for you, which that's the bottom line in all of these. And what may happen is that you'll both have to give it up and then you'll be selling it at a discount and nobody wants that.
Yeah, absolutely. And so it seems to me, if you have a business with your partner and you are divorcing but want to keep the business, collaborative law is absolutely the way to go. That makes perfect sense. Fantastic.
Now it's interesting because I interviewed a couple, husband and wife, who were mental health counselors, and they specialized in counseling couples in business. And so I brought them into my collaborative divorce group and we created this kind of scenario where all of the teams worked on this fantasy couple who wanted to get divorced but keep their business in place. And this couple who counsel couples in business together helped us do that, it was an awesome experience and helped us tremendously in our actual day-to-day work.
I can well imagine. That is fantastic. Very, very instructive for me as well. Joryn, I really appreciate you sharing that. One last question then. Where'd you find the name Open Palm Law? How does
you sound like a lawyer. One last question. Yeah, I'll believe that when I see it. Open Palm Law. Well, it used to be Joryn Jenkins, JorynJenkinsLaw.com. And my office was your typical office. The thing is that we don't think about body language, facial expression, spaces that we're in. So lawyers tend to like highly air conditioned, very clean, white square tables, sharp edges, not real comfortable. You can see my my poster behind me. This is actually my home, but I have the same artwork at my office now. It's all Tommy Bahama, very comforting, tile floors. It's not marble. It's none of that. And by the same token, the title, words are so important, which is why I have trouble with Joryn. I love my name, but it's off-putting because people aren't sure how to pronounce it. And I bet you dollars to donuts that there have been people who thought, oh, well, I'll call this one. And then they go, oh, I'm not sure how to say that. Right? So you guys have it easy because it's Deborah and Sonia. And yeah,
Yeah.
I love being unusual, but it does have its drawbacks. And so I decided, okay, I'll take a cue from my husband, who has 4 black belts. And he's always said, you know, better an open palm than a closed fist, because an open palm holds more than a closed fist. And
Isn't
so I
that
thought,
true?
what a lovely mantra for protecting a family, open palm, restructuring a family rather than blowing it up, right? So
Yep.
that's what we did.
I love it. Fantastic. Joryn Jenkins, thank you for sharing the information about mediation and collaborative law. Openpalmlaw.com is where to find you. Are there other places to find you online?
Oh, sure. I've got a marketing website, jorynjenkins.com, spelled like my name. And then I'm on LinkedIn, it's Joryn Jenkins. I'm on Facebook, it's Open Palm Law, and also Joryn Jenkins. I'm on Instagram. I'm not very active on Instagram or Twitter. I'm not quite comfortable over there, but you know, I'm there. I have a presence. Oh, and go to YouTube. That's where I'm really, I have a ton of videos, lots of information on collaboration versus litigation. I've got a lot of marketing for lawyers as well as.
Fantastic. Thank you so much, Joryn. We appreciate your information, and we will see you again soon. All right. Fantastic, fantastic. I love the whole concept of collaboration in mediation. It seems to me if you have or can gain the proper respect for your partner, everything gets so much simpler that way. So very, very smart way to go about it there.
Yeah.
Deborah, you want to take us home?
Okay. Today's quiz. Which role is equivalent to plaintiff in a lawsuit? Is it petitioner, claimant, complainant, or all of the above? And you know, when you have a question that's all of the above, at the bottom, it's always all of the above. A plaintiff can be a petitioner or claimant or a complainant.
I love it.
Yeah, that's a test freebie right there. Okay, that's it.
Fantastic, fantastic. You know, that is a test freebie, as you said. I made good use of those back in standardized testing days, and so I remember that one, that truism as well. Fantastic.
Let's see, we're gonna get some people in trouble.
Hey, you check that one off. Check that one off and move on. Okay, that's great. That is great.
All right.
All right, that's all we have for you today. Thanks so much for joining us, and we will see you next time.
Are you feeling beleaguered, angry, or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court. Or, if someone takes you to court, you can take them to school.